Good night, Ian. Good morning. Please be seated. I will try to keep my coughing and blowing my nose to a minimum today. There you are. All of a sudden, I'm like, where'd she go? I left. I tried again. This was not typing. I tried with my password and it didn't let me in. So I think you have to put me back in the system. Not that it matters at this point, I guess, because who knows when you'll see me again. Thank you. Appreciate it. Ms. Runty, are we ready for the jury?
Yes, Your Honor.
Mr. Carmen, ready for the jury?
I'm sorry, I was having...
Don't apologize. No, I didn't want to interrupt you. So.
No, I'm ready.
Okay. Ms. Jane, could we have the jurors, please? Or Ms. Jeanette, too. Oh, she was back there. Please be seated. Good morning. We're back on the record in 22 CF 134. People versus Daylon Richardson. Mr. Richardson appears here with Mr. Carmen, the state by Ms. Runty. The jury is seated. It's 9:11 a.m. To resume trial today. Ms. Runty.
Your Honor, the state has no further witnesses to call, no further evidence to present. We would rest our case.
Thank you. The state has rested their portion of the presentation. And because she's choosing to do that, I must ask you to go back to the jury room for a few minutes. So, thank you. Please be seated. Mr. Carmen.
Your Honor, I would make a motion for a directed verdict at this point. My argument is very simple. By the way, as to counts 1 and 2, making a directed verdict in that testimony of the state's expert witness, Sergeant Kuhn. I asked him quite clearly if it was possible that Mr. Richardson never regained control of his vehicle after he left the roadway.
Pull up your mic.
Sorry.
That's all right. Thank you. Thank you.
Never regained control of his vehicle after he took it off the roadway, that his reaction time was very slight based upon the speeds of the vehicle, the speed of his vehicle, and the distance from the point at which he left the roadway until the point that he struck Deputy Weist. I think even viewing that evidence in a light most favorable to the state, there is reasonable doubt as to whether my client intended to kill or drove his vehicle with such intentionality that the court would have to conclude that he intended to cause bodily harm or death to Deputy Weist.
Thank you. Ms. Runty.
If the court will recall, crash reconstructionist Kuhn also testified on redirect examination that while that is certainly a possibility, as he deals in possibilities with his scientific portions of his duties, that it was not his belief, based on the evidence that was in front of him, that that was what had occurred on this date at the incident scene, and that it was his belief, based on the evidence in front of him, that there were inputs put into the vehicle, steering maneuvers that had been made, and that those were on purpose. So I do believe that as to those issues, that the state has presented adequate evidence, and that their motion for a directed verdict should be denied.
Viewing the evidence and testimony in the light most favorable to the state, I believe the state has set forth sufficient facts for a trier of facts, which is the jury, to determine whether or not the state has met their burden of proof on all 4 counts. So for those reasons, Mr. Carmen, your motion for directed verdict is denied. Do you want a few moments with Mr. Richardson?
No, he and I have made this decision already.
Okay. So, Mr. Richardson, you understand you have an absolute right, constitutional right, to not testify. Do you understand that?
Yes, ma'am.
And that if you choose not to testify, Mr. Richardson, the jury cannot hold that against you. As you sit there, you are not guilty, Mr. Richardson. You understand that?
Yes, ma'am.
And that you understand that it is the state's burden and will remain the state's burden of beyond a reasonable doubt to prove each element of the offenses that are charged against you.
I do, Your Honor.
Okay. Do you feel that you have had sufficient time and opportunity to discuss your decision with Mr. Carmen?
Yes, ma'am.
And are you satisfied with your conversation with Mr. Carmen
Yes, ma'am.
and his counsel?
Yes, ma'am.
And so at this time, Mr. Richardson, the court is asking if you are choosing not to testify or to testify on your own behalf, sir.
I am not testifying.
Okay, thank you. So we'll call the jurors back into the room, please. We could have the jurors, we're just trying to get them to have steps, get their steps in today, right? Please be seated. Mr. Carmen.
Yes, Your Honor, thank you. My client has elected not to testify, and we are not putting on any evidence of our own.
Thank you. So the defense rests.
So the defense rests.
Thank you, sir. So ladies and gentlemen of the jury, at this time, because the attorneys and myself have to do some administrative things before I give you the case, I'm going to ask you to go back to the jury room. We're just trying to get you to have your steps get in today. So we hopefully won't be horribly long. So I brought bagels hoping that would entertain you for a little bit this morning. So I'm going to ask you to go back to the jury room and let us take care of our administrative things, and then we'll have you brought back in. Thank you.
No, that was something that I had left.
Oh, okay. All right. I thought you wanted something to write on. Please be seated. So the jurors are out of the room at this time. Ms. Brunty and Mr. Carmen, let's do our jury instruction conference, please.
That'll work for me then. I've got to put mine in order now.
Ready?
Yes, ma'am.
So I I have what's been numbered as People's Instruction Number 1, IPI Number 1.01. Members of the jury, the evidence and the arguments in this case. Mr. Carmen.
No objection.
So that will be given without objection. Then I have what's been numbered as People's Instruction Number 2, IPI Number 1.01A. Members of the jury, the trial is about to commence, which is always kind of weird, and I did give that at the beginning.
You did.
Typically, I apologize, typically, Your Honor, I provide that as a part of the instructions, but since the judge reads that at the beginning, they typically choose not to give it.
I understand, and every place that I've done a trial in our circuit, I always get this jury instruction proposed by the state, and when we come to it, and I'm grateful to the attorneys that do this, in case we forget at the beginning, I think the state moves to withdraw.
So I'll withdraw People's Instruction 2.
Okay, so People's Instruction Number 2 is withdrawn. Then I have what's been numbered as People's Instruction Number 3, IPI Number 1.01, capital B. We all have feelings, assumptions, perception, fears, stereotypes. Mr. Carmen.
No objection.
That will be given without objection. Then I have what's been numbered as People's Instruction Number 4, IPI Number 1.02. Only you are the judges of the believability of the witnesses. I'm going to do this one together with People's Instruction Number 5, which is also IPI Number 1.02. The difference between 4 and 5 is that on 4, it has the single line denoted as a separate paragraph. You should judge the testimony of the defendant. People's Instruction Number 5 omits that sentence.
I'll withdraw People's Instruction Number 4.
Okay, so People's Instruction Number 4 is withdrawn, and People's Instruction Number 5, IPI Number 1.02, only you are the judges of the believability of the witnesses. Mr. Carmen.
No objection.
That will be given without objection. Then we have People's Instruction Number 6, IPI Number 2.04, the fact that the defendant did not testify. Mr. Carmen.
No objection.
That will be given without objection. Then I have what has been marked as People's Instruction Number 7, IPI Number 1.03. Opening statements are made. Mr. Carmen.
No objection.
That will be given without objection. And I have, it's been numbered, People's Instruction Number 8. Those of you who took notes, Mr. Carmen.
No objection.
Given without objection. Then I have what's been numbered as People's Instruction Number 9, IPI Number 2.01R. The defendant is charged with the offense of murder. The defendant has pleaded not guilty. Under the law, a person charged with murder, and in parentheses it says intent to kill or do great bodily harm, may be found, 1, not guilty of murder, parentheses, intent to kill or do great bodily harm, and not guilty of aggravated reckless homicide, semicolon, or 2, guilty of murder, parentheses, intent to kill or do great bodily harm, semicolon, or 3, guilty of aggravated reckless homicide. And then it goes into the defendant is charged with the offense of murder, and it goes for all of that. Mr. Carmen.
I've had some concerns about this instruction since it was tendered. The jury has not yet, well, I guess they will have heard in my closing argument, and possibly Ms. Rente's, about aggravated reckless homicide. But that will be the first they hear of it.
No, I know.
So,
And obviously, you know, you or she or,
I suppose this is really the only way to do it.
well, and it's the IPI instruction number. I guess my question is,
So this was the one, Your Honor, that from previous conversations, I had changed what was in the parentheticals to more closely reflect the statutory language as opposed to factual language.
right,
After discussion among the parties. So
Right.
that change has been reflected here
Right.
as you read.
okay. So, Mr. Carmen, as to People's Instruction Number 9, IPI number 2.01,
No objection.
so that will be given without objection. There's People's Instruction Number 10, IPI number 28.01. The state has also alleged that when the defendant committed the offense of murder, parenthesis, intent to kill or do great bodily harm, and murder, parenthesis, strong probability of death or great bodily harm, the defendant murdered a peace officer when the officer was killed in the course of performing his official duties, and the defendant knew or should have known that the murdered individual was a peace officer. The defendant is denied this allegation. Mr. Carmen.
Just a grammatical change. I think
Okay.
these allegations, because there's two. One is that he was a peace officer in the course of performing his official duties, and that he should have known that he was, knew or should have known that he was a peace officer. So I think that's plural.
Where?
The last line has denied these allegations.
Oh. All right, so, we'll annotate that. Well, if we change the defendant has denied these allegations with an S, once that's changed, any objection?
No.
So we'll get it edited and then changed and review it. It's been marked as People's Instruction Number 11, IPI number 2.02. The charges against the defendant in this case are contained in, Mr. Carmen,
No objection.
be given without objection. And People's Instruction Number 12, IPI number 2.03. The defendant is presumed to be innocent of the charges against him. Mr. Carmen,
No objection.
that will be given. And I have People's Instruction Number 13, IPI number 28.02. The state has alleged that the murdered individual was a peace officer killed in the course of performing his official duties. The defendant is presumed to be innocent of this allegation, and the presumption remains with the defendant throughout every stage of the trial and during your deliberation on the verdict, and is not overcome unless from all the evidence in this case you are convinced beyond a reasonable doubt that the allegation is proven. The state has the burden of proving the allegation beyond a reasonable doubt, and this burden remains on the state throughout the case. The defendant is not required to disprove the allegation. Mr. Carmen.
I believe this is incomplete in that it discusses only that he was a peace officer killed in the course of performing his official duties. It does not make any reference to the fact that the state has the burden of proving beyond a reasonable doubt that my client knew or should have known that he was a peace officer.
I can double check the IPI, and certainly if that language is in the IPI, I would not object to adding it. If it's not, then I would.
So, and I may be wrong, but I have a portion of 28.01, the IPI. And the state has also alleged the defendant murdered a peace officer when the police officer was killed in the course of performing his official duties, and the defendant knew or should have known that the murdered individual was a police officer.
I have that instruction included later, Your Honor, and I have 28.02 pulled up from the,
Okay,
Court
I'm
website.
reading 28.01.
I understand, and I have 28.01 included later in the instructions packet
Okay,
with that language
Okay.
that he knew or should have known.
and so 28.02.
Does not read that way.
Mr. Carmen, you want to go look at that?
No, I understand exactly what she's saying, but in the sequence of events, of instructions as you give them, you're going to be telling them first this is what they have to find, prove my client guilty beyond reasonable doubt. And then they're going to get an instruction that says, oh no, they also have to throw this one in there too. That seems confusing to me.
As I said yesterday, I understand what Mr. Carmen is arguing. Unless there is not an IPI instruction that specifically addresses the matter at hand, or it's misstating the law, I don't like creating an instruction. So tell me what 28.02 says, please.
On the illinoiscourts.gov website that contains the most recent updates for the Illinois pattern instructions, 28.02, enhancement/extended term factors, presumption of innocence, dash reasonable doubt, dash burden of proof reads. Okay, there's all kinds of brackets in here. The state has alleged that insert the appropriate enhancement or extended term factors. The defendant is presumed to be innocent of these allegations. This presumption remains with the defendant throughout every stage of the trial and during your deliberation on the verdict, and is not overcome unless from all the evidence in this case, you are convinced beyond a reasonable doubt that the allegations are proven. The state has the burden of proving the allegations beyond a reasonable doubt, and this burden remains on the state throughout the case. A defendant is not required to disprove these allegations. And there's committee notes under it that say, give instruction 28.01, give 28.03.
Understand. And I think this, Mr. Carmen, 28.02, because I'm reading it, is essentially stating that Mr. Richardson is presumed innocent of the allegations, and that remains with him. I don't know if that's the proposition instruction, because I'm reading it right now, and I can see the committee notes, give instruction 28.01, give instruction 28.03 and 28.04, and in perusing the other proposed instructions, those are included in there, because the 28.03 is issues and enhancement or extended term factors to sustain the charge, and I see that later. So I don't think that it's confusing. I think this is a general statement that Mr. Richardson is presumed innocent of those allegations and that it's the state's burden. So if you're objecting to people's instruction number 13, we'll note that for the record, and I'm going to give it with objection. Then we have what's been numbered as people's instruction number 14, IPI number 3.02, circumstantial evidence. Mr. Carmen
No objection.
will be given. Then I have people's instruction number 15, IPI number 4.08, the term peace officer means. Mr. Carmen,
No objection.
given without objection. I have people's instruction number 16, IPI number 5.01, a person acts recklessly when he, Mr. Carmen.
Yes, that's acceptable.
I'm sorry?
It's acceptable.
Oh, I'm sorry. Will be given without objection. My ears are stopped up, so
And my voice got caught.
sorry. People's instruction number 17, IPI number 5.01, capital B. A person acts knowingly with regard to the nature or attendant circumstances of his conduct when, Mr. Carmen.
1 second, please.
Sure.
No objection.
That will be given without objection. People's instruction number 18, IPI number 7.01, capital B. A person commits the offense of murder when, Mr. Carmen.
No objection.
That will be given. People's instruction number 19, IPI number 7.01, capital B. Is the same instruction as people's instruction number 18.
It's not the same, it's slightly different. No objection.
It's slightly different because of the parenthetical.
Correct.
Okay. Any objection, Mr.
No,
Carmen?
no
That will be given. People's instruction number 20, IPI number 7.02, capital B. To sustain the charge of murder, the state must prove the following propositions. First proposition, that the defendant performed the acts which caused the death of Nicholas Weist. And second proposition, that when the defendant did so, number one, he intended to kill or do great bodily harm to Nicholas Weist, or number two, he knew that his acts created a strong probability of death or great bodily harm to Nicholas Weist. If you find from your consideration of all the evidence, and it goes forth from there, Mr. Carmen.
No objection.
That will be given without objection. People's instruction number 21, IPI number 28.03. To sustain the allegation made in connection with the offense of murder, the state must prove the following propositions. Proposition, that when the defendant committed the offense of murder, the defendant murdered a peace officer when the peace officer was killed in the course of performing his official duties, and that the defendant knew or should have known that the murdered individual was a peace officer. Mr. Carmen.
I know these are IPI, Your Honor, but I would still say following propositions, because they're
I agree.
They're separate propositions.
I agree. So we need an S following the word proposition,
That's it.
and then once it's edited, we'll review it, and Mr. Carmen can make his objection or not, no objection.
No objection other than that.
Okay. And we have people's instruction number 22, IPI number 7.09, capital A. A person commits the offense of aggravated reckless homicide when he unintentionally causes the death of a peace officer during the course of his official duties as a peace officer by driving a motor vehicle recklessly and in a manner likely to cause death or great bodily harm. Mr. Carmen.
No objection.
So that will be given without objection. People's instruction number 23, IPI number 7.10, capital A. To sustain the charge of aggravated reckless homicide, the state must prove the following propositions. First proposition, that the defendant caused the death of a peace officer during the performance of his official duties as a peace officer by driving a motor vehicle. And second proposition, that the defendant drove a motor vehicle recklessly. And third proposition, that the defendant drove a motor vehicle in a manner likely to cause death or great bodily harm. If you find from your consideration of all the evidence, and it continues from there. Mr. Carmen.
No objection.
That will be given without objection. Then I have People's Instruction number 24, it's 2 pages, IPI number 26.01R. When you retire to the jury room. Mr. Carmen.
No objection.
That will be given without objection. I have People's Instruction number 25, IPI number 28.04. The state has also alleged that the defendant murdered a peace officer, and the peace officer was killed in the course of performing his official duties, and the defendant knew or reasonably should have known that the murdered individual was a peace officer. You find the defendant is not guilty of the offense of murder, you should not consider the state's additional allegation regarding the offense of murder. If you find the defendant is guilty of murder, you should then go on with your deliberation to decide whether the state has proved beyond a reasonable doubt that the allegation that the murdered individual was a peace officer killed in the course of performing his official duties. Accordingly, you will be provided with 2 verdict forms. Quote, we, the jury, find the allegation that the murdered individual was a peace officer killed in the course of performing his official duties was not proven. And, quote, we, the jury, find the allegation that the murdered individual was a peace officer killed in the course of performing his official duties was proven, excuse me. From these 2 verdict forms, you should select the one verdict form that reflects your verdict and sign as I have stated. I don't see, because at the top, Ms. Runte, you have, and the defendant knew or reasonably should have known that the murdered individual was a peace officer, but that is not included in the
verdict
anywhere
form,
else.
in the verdict form description.
Well, in the verdict forms, or the state has proved beyond a reasonable doubt that the allegation that the murdered individual was a peace officer killed in the course of performing his official duties, and to reflect the same language in the first paragraph.
Well, I'm struggling with something else, Your Honor. In the first, and again, it really doesn't affect what I do, but I don't want the jury to get confused. If you find the defendant guilty of murder, you should go on with the, well, excuse me. If they find the defendant not guilty of murder, they still are going to be asked to decide under the aggravated reckless homicide statute if defendant was a peace officer killed in the course of performing his duties.
Yeah, but that's in that proposition.
That's not, that's in the aggravated reckless, in the statute, the aggravation,
Regarding, I see.
Do you see?
I see the last clause of the sentence covers that.
yes,
That's fine.
okay.
Okay, so I flipped over to 28.04 on the illinoiscourts.gov website. When it gets to the end, after all of the choices.
Sure.
Okay? That is the paragraph that it gives. If you find the defendant not guilty of the offense of blank, you should not consider the state's additional allegations regarding the offense of blank. If you find that the defendant is guilty of blank, you should then go on with your deliberation to decide whether the state has proved beyond a reasonable doubt the allegation that, and then it says insert the appropriate enhancement / extended term factors.
Right, and under, if you look at the, go back to 28.01, it has that the murdered individual was a peace officer killed in the course of performing his official duties, and that the defendant knew or should have known. So if we want to call it, if you want to call it modified, but I want the language in this paragraph and in the verdict forms to match the language in the first paragraph of your People's Instruction number 25.
This is, what instruction?
So People's Instruction number 25,
Right.
all right? So the third paragraph, it should read, if you find the defendant is guilty of murder, you should then go on with your deliberation to decide whether the state has proved beyond a reasonable doubt the allegations that the murdered individual was a peace officer killed in the course of performing his official duties, and that the defendant knew or should have known that the murdered individual was a peace officer.
From instruction 10?
Yes. And really, it's, if you look up at your first paragraph in People's Instruction number 25, it has that same language. Your very first paragraph on this same instruction. The murdered individual was a peace officer killed in the course of performing his official duties, and the defendant knew or reasonably should have known that the murdered individual was a peace officer.
Okay, I'll drop that language down.
Well, and then the next paragraph, accordingly, you will be provided with 2 verdict forms. Quote, we the jury find the allegations that the murdered individual was a peace officer killed in the course of performing his official duties was not proven. So an S in there. And we the jury find the allegations that the murdered individual was a peace officer killed in the course of performing his official duties was proven, and the defendant knew or reasonably should have known that the murdered individual was a peace officer. So you need to add that to
The last part of
the last part of paragraph 4.
Okay.
Mr. Carmen, any?
With the court's corrections, I wouldn't have any objections.
Okay. And then we're on to People's Instruction number 26, which is IPI number 26.02. We, the jury, find the defendant, Daylon Richardson, not guilty of the offense of murder, and in parentheses, intent to kill or do great bodily harm, and not guilty of the offense of aggravated reckless homicide. Mr. Carmen?
No objection.
Given without objection. And then I have People's Instruction number 27, IPI number 26.05. We, the jury, find the defendant, Daylon Richardson, guilty of the offense of murder, parentheses, intent to kill or do great bodily harm.
No objection.
That will be given without objection. Then I have People's Instruction number 28. We, the jury, find the defendant, Daylon Richardson, guilty of the offense of aggravated reckless homicide. Mr. Carmen?
No objection.
Will be given without objection. Then I have People's Instruction number 29, IPI number 26.02. We, the jury, find the defendant, Daylon Richardson, not guilty of the offense of murder, parentheses, strong probability of death or great bodily harm, and not guilty of the offense of aggravated reckless homicide. Mr. Carmen?
No objection. No objections.
That will be given without objection. Then I have People's Instruction number 30, IPI number 26.05. We, the jury, find the defendant, Daylon Richardson, guilty of the offense of murder, parentheses, strong probability of death or great bodily harm. Mr. Carmen?
No objection.
That will be given without objection. Then I have People's Instruction number 31, we, the jury, find the defendant, Daylon Richardson, guilty of the offense of aggravated reckless homicide. Mr. Carmen,
No objection.
that will be given. Then I have People's Instruction Number 32. We, the jury, find the allegation that the murdered individual was a peace officer killed in the course of performing his official duties was not proven. Mr. Carmen?
Same problem as before, Judge, there needs to be reference to.
No, this is that,
Was a peace officer killed in the course of performing was not proven, that's, if there's no separate instruction form, knowing.
there is, the next one is,
I don't have it.
we, the jury, find the allegation that the murdered individual was a peace officer killed in the course of performing his official duties was proven. I want her to add on that instruction that the allegation that the murdered individual was a peace officer killed in the course of performing his official duties and that the defendant should have known.
That's fine.
So with number 32, do you want that language added as well?
I do.
Okay, so People's Instruction Number 32, please add, in the course of performing his official duties and that the defendant knew or reasonably should have known that the murdered individual was a peace officer was not proven, in the same for People's Instruction Number 33. Does all that make sense, Ms. Renton? We're just matching the language.
Yes, and so I'm going to ask if you want to go back to the other one, because we did not add in the other one that.
I agree, we didn't add it in there.
If you put it one place, you have to put it the other
I
place.
agree.
And while I would say that I
So
don't
tell
think
me,
we should
tell
go
me
either.
where.
On.
For-
People's 25,
Number 25,
yeah.
so yes,
If that's what you're doing, which
I agree.
I would still make the argument that if it's not proven, it's not proven. It doesn't matter what part of it is not proven.
I understand, but I think for consistency, and for, so there's no confusion for the record or for the jurors, let's just have the language match. I don't necessarily disagree with you, but, Mr. Carmen has a point, so.
So do you want me to say, okay, so in there, find the allegations that the murdered individual was a peace officer killed in the course of performing his official duties, and that the defendant knew or reasonably should have known
That the murdered individual
was a peace officer was not.
was not proven.
You don't mean to make that clause negative, just leave the negative at the end. Okay, I just,
They still be consistent. Peace officer not being enforced. So that's why.
And we'll give you a few minutes to get those changes and copies.
okay, do you want to, do we have any defense instructions, or do you want to do these separately?
No, because
That's-
of the
you're
way
fine.
you tendered it, I'm fine with it.
So you have no,
I'm not going to tender
You're
a
not-
plain old reckless
Okay.
homicide instruction because the sentencing range is the same.
which makes sense. Okay, so you want a few minutes to get those, because by my count, my turned correction sheets, there's 5 pages.
Five.
Okay. All right, so we'll, let's do about a 10-minute recess to give her a chance to get that stuff done. I don't expect her to be running all over the buildings for, so. We'll be in recess for about 10 minutes. It's a bad thing that when I blow my nose, my ears are popping. That's never, is that what it is? Never, I've never had that happen. So, Mr. Carmen, what would be numbered as People's Instruction number 25, the one that has been moved on to 2 pages now. Paragraph 3 contains the S after allegations. Would you agree?
Yes.
And in paragraph 4, Ms. Runte has added the S to allegations as well as, and that the defendant knew or reasonably should have known in both spots. Would you agree?
Yes, I would.
So with regards to People's Instruction number 25, any objection, Mr. Carmen?
No.
So that will be given. And then I have and on the second page of that jury instruction number 25, she added the S to allegations.
Yes.
Okay. And then she has tendered bear with me. People's Instruction number 32, which is, she added the S to allegations, and she added the language of knew or reasonably should have known. Would you agree, Mr. Carmen?
I would.
And any objection as edited?
No.
So that will be given. And then I have what will be marked as People's Instruction number 33, IPI number 28.06, excuse me. And Ms. Runte has added the S to allegations as well as the language of knew or reasonably should have known. Would you agree, Mr. Carmen?
I would, without objection.
And that will be given without objection. Talk about killing trees. Okay. The party is ready to proceed. Bring the jurors back, do closing arguments.
That's right.
Please be seated. Back on the record in 22 CF 134, all parties are present, the jurors are reseated. It is 10:39 a.m. Thank you all for your patience. Ladies and gentlemen of the jury, you have heard all of the evidence in this case, but the trial has not ended. At this time, the attorneys have the opportunity of making final arguments. First the state, then the defense, then the state will have a chance to respond to the defense's argument. What the attorneys say during the arguments is not evidence and should not be considered by you as evidence. After you have heard the arguments, I will instruct you on the law, and then you will retire to your jury room to consider your verdicts. Ms. Runty, is the state ready to proceed?
We are.
Mr. Carmen, is defense ready to proceed?
We are.
Ms. Runty?
May it please the court. Mr. Ladies and gentlemen, thank you for your time and your attention on this case. When you imagine what your possible jury service might look like, I'm not sure this was on your radar. I want to take some time to go through a few of the jury instructions with you. The judge will read you these instructions along with others in a few minutes, and you will get a printed copy to take to the jury room with you. There are jury instructions about the charges and about what I need to prove to you. To sustain the charge of murder, the state must prove the following propositions. First proposition, that the defendant performed the acts which caused the death of Nicholas Weist. And second proposition, that when the defendant did so, he intended to kill or do great bodily harm to Nicholas Weist, or he knew that his acts created a strong probability of death or great bodily harm to Nicholas Weist. To sustain the allegations made in connection with the offense of murder, the state must also prove the following proposition. That when the defendant committed the offense of murder, the defendant murdered a peace officer when the peace officer was killed in the course of performing his official duties, and that the defendant knew or should have known that the murdered individual was a peace officer. Please keep in your mind that the burden of proof is beyond a reasonable doubt. Let's look back through the evidence and the testimony and how it shows you that Daylon Richardson is guilty of murder. We heard first from Officer Jared Tapscott of the Galesburg Police Department. He was the lead police vehicle in the pursuit from Galesburg, and you had an opportunity to view a portion of his squad video and his body camera video. From that, we learned that the pursuit from Galesburg to the intersection of Route 150 and 150th Avenue in Henry County took approximately 12 minutes due to the high rate of speed which the vehicles were traveling. We also know that Officer Tapscott had his lights and sirens on the whole time and was doing his best to keep the fleeing Ford in his sights. We heard Officer Tapscott relay to dispatch that he saw a weapon displayed from the vehicle and later that shots had been fired out the Ford's back window. We also heard from Lieutenant Carl Kramer from the Knox County Sheriff's Office. He was the supervisor on duty on the morning of April 29th of 2022. Knox County deputies have take-home squad cars, and Nick was driving a squad car home after his shift on that day. We learned that their practice is to sign off just prior to getting out of their squad car. A practice put in place, no doubt, so that the general motoring public who saw a squad car would know that the person could be counted on for help. The general duties of police officers include responding to calls, making arrests, and assisting other agencies. On the Knox County radio calls, we heard deputies indicating where they were in relation to the pursuit, indicating that they wouldn't be there in time to intercept. And then we hear Deputy Weist telling the dispatch that he'd be near the county line He asks whether Galesburg is requesting the use of the spike strip and whether it is authorized. We heard on the radio and we heard from Lieutenant Kramer that he authorized that spike strip deployment. We know what happened next. Deputy Weist threw out the spike strip, and the Ford, which had been traveling in the northbound lane, diverted to the right to avoid the spikes, driving into the gravel and the grass. We also know that, based on the tire markings of the scene, the Ford turned back onto the roadway and finally made another turn to the right, bringing it in contact with Deputy Weist and the corner of the spike strip. The photos and the diagrams from the scene show us that the Ford traveled into the west ditch, overturning and eventually coming to rest upright. And Deputy Weist was projected 127 feet. Ladies and gentlemen, that's more than 40 yards. Landing in the west ditch, where he was later pronounced deceased as a result of the injuries that he sustained from being struck by the fleeing defendant. A defendant who was so intent on getting away from the police that day that even after his vehicle wrecked, he fled on foot until officers chased him down in the field. The testimony and the evidence that you have in front of you shows that Daylon Richardson performed the acts that caused the death of Deputy Weist. They show you that any reasonable person would have known Deputy Weist to be a police officer performing his official duties. And they show you that the defendant's actions were all choices, reflecting that it was his intent to get away from the police at any cost that day. And I ask that you find him guilty of murder.
Thank you, Ms. Renton. Mr. Carmen.
Thank you, Your Honor, and please support. Elected official gets to do, and I've been particularly impressed with the amount of attention paid to the various forms of evidence that you've received in this case. You've had videos, you've had pictures, you've had something called orthomosaic photographs, something I never heard until this. So you've had a lot to digest in a short period of time. But I want to go over a couple of things about your deliberations before I start addressing the evidence as Ms. Renton presented. First thing I want to go over is what does it mean for the state to prove something beyond a reasonable doubt? As I told you back on Tuesday, I can't tell you what that means. Judge Kowsledge can't tell you what it means. You have to decide what it means. But I do get to give you a hint. And the hint that I give you is this. If in assessing a proposition, a right or wrong proposition, it doesn't come to you immediately what the conclusion is, that sounds like a reasonable doubt to me. Let's talk about something else that's very difficult to talk about, but it's part of this case and there's no avoiding it. And that is the judge's instruction to you that neither sympathy, bias, nor prejudice, whether you acknowledge it openly or it's implicit within you, should be part of your decision. Now, it's hard not to have sympathy. You would be less than human if you didn't have sympathy for the enormous loss suffered by not just his family, but by the community at large as it relates to Nick Weist. It's not easy being a police officer. And when a police officer gets killed, people get upset. And the people that you've seen every day, the folks on this side of the aisle, are good people, and they care. And they have sympathy, they have bias, and their feelings have been damaged irreparably. But none of that can figure into your deliberations, into your verdict. The judge will tell you neither sympathy, bias, and there's a few other things, should enter into your deliberations. You should make this decision based upon the evidence. And Ms. Ruttke gave what I would consider a fine summary of her version of the evidence, but much as has occurred throughout this case, a lot of the evidence didn't quite come in until I brought it. And that is, there's two things. Number one, Officer Capscott. I asked Officer Capscott, was your vision, what you saw that day as you were pursuing Mr. Richardson, was that better than the photo quality or the video quality that we saw? And he said, yes. And I said, did you see Daylon Richardson leave the roadway when Deputy Weist appeared? Yeah, I saw it. But oddly, you didn't hear anything about that in his presentation, in his testimony, in his presentation case. You never heard that. And the one thing, the big thing, that you didn't hear until I brought it out was how far it was and what time element was involved. From the time that Daylon Richardson made the decision, again, visual, first the visual, sees the police officer, or sees the police car. We don't see the police officer right away because he's back behind his vehicle, opening up the stop sticks. Sees the car, says, oh my God, he's throwing stop sticks down when he sees that. How much time did he have from the time he made the first calculation in his brain that there's a guy out there who's going to put down things that are going to make my car's tires go out, and I'm not going to be able to leave. And we know, as Ms. Runte acknowledged in her argument, there's a serious flight or fight mentality going on with Daylon Richardson. We'll get to that in a second. But one thing we know consistently throughout the videos, consistently from the testimony of Officer Capscott, consistently from the testimony of other officers, this pursuit took place over a long period of time, somewhere between 95 and 110 miles an hour. I had generously, in my calculations, said, let's use the 100 mile an hour figure, even though we know that speeds were exceeding 100 miles an hour during this chase, and for large portions of it. At 100 miles an hour, the vehicle travels 146.7 feet per second. And I asked Sergeant Kuhn, how far was it from the point that Mr. Richardson left the roadway to the point of impact? 160 feet. How much time, at 100 miles an hour, does he have to see, react, turn, strike the officer and kill? How much time does he have? Almost nothing. And what verifies that? Deputy Weist's squad car video. You saw it, you all saw it, it was quite shocking. Throws the sticks down, and before you can say Jack Robinson, he's hit. And he's hit hard, hit fast. So the conclusion that you should reach is, unlike the Sergeant Kuhn's attempt to say that the vehicle might have been slowed by dirt, or might have been slowed by the rougher terrain that you came onto. He didn't slow down that much. We're talking about less, I would say, a second, at the best, a second and a half. What kind of intent can you say in a second and a half? Let's talk about Mr. Richardson for a second here. Mr. Richardson is from Granite City, Illinois. You've heard that evidence yesterday. It's a suburb of St. Louis. What is he doing in Galesburg, Illinois, 211 miles away at 8 o'clock in the morning? What the judge will instruct you is that you are to use your own common sense in making these determinations, and you can draw inferences from the evidence. One of the very logical inferences from this evidence is that Daylon Richardson's brain process on the morning of April 29, 2022 was not exactly calm and deliberate. Police officer sees him in possession of a firearm at a convenience store gas station, and instead of just, hey officer, yeah, here I am, I got a gun, he runs. And he sees the alarm, he sees the flashing lights, and he doesn't stop. Pure flight or fight reaction. He's not thinking clearly. And then what happens next? He goes on a 12 to 13 minute high-speed police chase. I'm guessing that none of you have had that pleasant experience in your lives. Pretty sure you haven't. Can you imagine what your brain would be like? I mean, what's your brain like when you're late for something, and you think you're in a hurry and you're driving 80 on a 70 mile an hour road? You feel like you're going pretty fast. Well, here's Daylon Richardson, 22 years old, in a place he probably may never have even been before, as far as we know. And he's racing up the back roads, which are not all flat and straight, at 95 to 110 miles an hour. What kind of judgment, what kind of intent can he form? No. This is pure reaction. And then let's talk about what happened physically when he goes into the road, comes back in the 160 feet that he has to traverse with 1.2, 1.3, 1.4 seconds. He loses control. He goes into, he's going about 100 miles an hour, and he goes into this loose gravel and grassy area. He loses control of his vehicle. He realizes he's going to crash in the upcoming farm. He realizes that. He also sees the stop sticks. He doesn't know what to do. He tries. He tries to get control of his vehicle, but he doesn't get it. Because nobody in their right mind was just trying to get away. Everything he's done, from the moment he saw police officers pursuing him in downtown Galesburg until the moment he crashed his vehicle into Deputy Weist, he was out of control. He didn't have his best faculties, his best abilities. And you may not agree with it. You may say, no, that's in a minute. A second is a second, but it's a second. That's where the concept of reasonable doubt kicks in. You may think ultimately that if somebody put a gun to your head, that he drove his vehicle intentionally into Deputy Weist, or that he drove in such a manner that he had to have known that they would be causing death or great bodily harm. You might think that. That might be something you think of, but you're also going to think of what Sergeant Hughes said. It's possible that he lost control of his vehicle. And if the vehicle doesn't work on its own, he's got a steering wheel, he can try. But for you to conclude under that set of facts, driving at that speed on unsurfaced or on an uneven roadway surface, even the road itself, you can see from the photos and the videos, it's cracked and a little bit worn. To say that, to believe beyond a reasonable doubt that he had such control of his vehicle that he drove into Deputy Weist intentionally, I don't see how you can find that. And if you can't find that, you can't convict him of murder. Now, one of the other things that you will see in your instructions that you didn't know anything about until, and you won't know anything about it until I tell you about it, is that you're going to be given an option. The state's instructions, the state's charge of murder are going to be one option, but you're also going to get what's called a lesser included offense instruction. That's a procedure in the law that allows the judge, allows you as the jury, to find Mr. Ruffin something other than what he's charged with. And I'm here to tell you today that you're going to get an instruction like that Mr. Richardson was guilty of aggravated reckless homicide. And I said it to you at the beginning of this case, and I'm going to say it to you now. This is only a murder case if you disregard everything about the mechanics and speed and the physics of this accident and just either feel sympathy or you don't something about Mr. Richardson you don't like, but you have an option. You can find him not guilty of those murder charges because you feel there's a reasonable doubt as to whether he had it. You can do that. But you also, as an alternative, can find him guilty of aggravated reckless homicide if you find that he drove a vehicle recklessly. You're not going to hear me arguing about that. You can't drive 100 miles an hour on a two-lane road, drive off the road, and not be reckless. So that's reckless. And that recklessness resulted in Nicholas Weist. Can't argue about that. So what I'm going to suggest to you, ladies and gentlemen, is when you go back and deliberate this case, that you come to the conclusion that it's just really unlikely that Daylon just had the opportunity or the ability or the physical wherewithal to control his vehicle at that speed and the short distance absolutely confirms that. He didn't have time to form an intent to kill. He didn't have time to form an intent as to anything. Like I said, he was in pure flight or fright. fight, it's harder to say than fought. But you can lie. And I suggest, and again, I hate to say that my client is guilty of anything, but if he is guilty of anything, he's guilty of reckless homicide, driving his vehicle recklessly that resulted in the death of another person. And I think you can conclude reasonably and beyond a reasonable doubt that that is what occurred in this case, not a murder. As I said to you Tuesday, this is as serious a case as there is, but it's not a complicated one. It's only complicated if you somehow jump from the evidence. This moved so fast and there was so little control involved that the state could never prove intent to kill or the second version. And I'm going to talk about that in a second. The second version of intent to kill. The second version of intent to kill is like this. Count one, murder intent. I aim the gun, shoot the court reporter. That's intent, that's murder. That's murder with intent. Count two, murder. Great possibility, high possibility, strong possibility of death as the result of the actions, of the intentional actions of the defendant. You may remember a few years ago, there was a gentleman who rented a hotel room in Las Vegas, got a bunch of AR-15s and AK-47s and other ammunition, went up in the room, and there was a country music concert playing in the strip below. He started firing. He just started firing. He didn't intend to kill anybody in particular like I just intended to kill the quarterback. But the law says when you act like that, when there's a high probability that you're going to kill someone when you take intentional acts like that, that's murder just the same as if I aimed a gun. There's a case in O'Hare Airport 15, 20 years ago. The guy drove his vehicle, there's a whole bunch of people standing on there, and he says, I'm going to kill some people today. So he drove them into the crowd. He didn't intend to kill anybody particularly. But his actions created a strong probability of death and great bodily harm. We don't have that in this case. We don't have that. We don't have Daylon Richardson doing something intentional with the idea of killing somebody. Daylon Richardson didn't wake up that morning, assuming he ever went to bed the night before. He didn't wake up that morning and say, I'm going to go out and kill somebody today. No. He went to get gas at a gas station. Oh, and they find him there with a gun. And that starts the process. When did he ever form the intent to kill? Now, that's a rhetorical question, and now I'm going to answer it but for a different reason. You heard a lot of evidence over the last few days about the gun and that Daylon Richardson fired a gun. When you hear the instructions, you're going to realize that act was not part of any of the charges that we're doing today. Court has admitted that evidence for reasons that are acceptable. I don't necessarily agree with them, but they're based on the law, and so I have no way of arguing against that at this point. But why are we spending all this time with the crime scene investigator showing where bullets came out of the vehicle, or show the crime scene investigator and the people who collected the casings and tied it up to Mr. Richardson? None of that stuff happened. By the way, none of that stuff happened in Denton County. If Mr. Richardson indeed fired shots that day, they were fired in Knox County. It's not charged in that here. It's not in front of you today. Why do we hear so much about it? Because the state wants to dirty up Daylon Richardson. The state doesn't want him dealing with 160 feet. They don't want that. They want you to know, he had a gun, he shot, he's a bad guy, he ran over Nicholas Weist, killed him, tragedy. That's not how you decide this case. You decide this case based on the evidence, not based on the fact that the state has gone to great lengths to prove that Daylon Richardson might not be the greatest human being alive. That's not what you should be doing. There's two more things I want to talk about. Number one is this whole issue of the second finding that you're required to make. You are required to make two more findings. If you find the defendant guilty of murder, you have to find two other things. You have to find that Deputy Weist was a peace officer in the course of performing his official duty, and two, that Daylon knew or should have known he was a peace officer. I'm not even talking about the second part, because that's all part of the evidence. We know What was in front of Daylon? We know that Daylon saw a police car. But did he know at the moment that he struck Deputy Weist that he was a police officer? 1.2 seconds. Is that knowledge? Or is that maybe? Maybe that's a police officer, maybe it isn't. He's got a uniform on, he's got a police car. I'm not going to fault you for making the fighting for the state in that part of the case. Because there's pictures, there's people, we see them, we know. Not your local electrician doesn't go laying out stop sticks in the local road. So I'm not going to argue that with that. However, was he in the course of performing his official duties? Sounds like a complicated phrase, no? Well, there's a famous passage in Through the Looking Glass, the book upon which Alice in Wonderland is based, where Humpty Dumpty says, when I use a word, I mean only what that word means. Nothing more, nothing less. And you have to decide today if the state has proved beyond a reasonable doubt that Deputy Weist was in the course of performing his official duties that day. And I'm putting that extra emphasis on the word official, because when the legislature used the word official in describing this finding, it implies the opposite, which is there are some things that a police officer does that are not official. That's why they put the word official in there, because that's what you have to find, beyond a reasonable doubt. Not if you think it's official, it may be official, maybe not. You have to find that he was not in the course of performing his official duties. If that's your state of mind. Let's look at the evidence. Nicholas Weist is was a Knox County deputy sheriff. Where was he when he got the call? Was it in Knox County? He'd already left Knox County. He'd gone, somehow he ended up on North 150th Avenue, because at least as far as we know, from his squad car, he didn't turn from the time that he got the call to the time that he came to the fatal intersection. Never, once his shift was over, then he was gone. The shift was over, he wasn't in Knox County. He doesn't have any official capacity in any other county. And I'm going to take issue right now with Lieutenant Kramer's testimony about this whole 1042 thing. He's not 1042 until he calls it in. And he can wait all the way until he gets to his home outside of Viola, Illinois, which is somewhere between 20 and 25 miles from headquarters. So in theory, Nicholas Weist, and I'm not suggesting he did this, there's no evidence that Nicholas Weist was anything but a really good cop and a really good person. And the fact that all these people are here prove that. There's no evidence that he did anything wrong. But the policy, do you believe it? Some of you have worked for the government at one time or another in your life, and some of us, like me, have been attorneys for governmental units. You did not see a written policy, a written program, saying that an officer is not off duty until he calls himself off duty. Wouldn't that be nice to have a job that says you're going to pay me for 15, 20, 25 extra minutes based on my own practices and my own whim? That sounds ridiculous. That sounds absolutely ridiculous, and I'm suggesting, again, Lieutenant Kramer struck me as a bad person, but that testimony, I don't know if it sounded contrived to you, but it sure as heck sounded contrived to me. Ladies and gentlemen, it is a great honor being here representing Daylon Richardson in this case. This is the highest and best thing a criminal defense attorney such as myself can do. And I've had a wonderful time doing it, but I greatly appreciate the service you've provided. And I think in the end, when you get right down to it, you're going to say, this is reckless homicide. It's a bad reckless homicide, but it's a reckless homicide. But it's not. They cannot prove beyond a reasonable doubt that Daylon Richardson intended to kill anybody, no less Deputy Weist. Thank you.
Thank you, Mr. Furman. Ms. Fronti?
Mr. Carmen has spent some time trying to convince you, most recently, that Deputy Weist was not acting within his official police capacity. He wasn't in the course of his official duties. I'm not sure how much more official police duties get, ladies and gentlemen, than stopping a fleeing vehicle, ensuring the safety of other citizens who are on the roadway. This is not a random person off the street who decided to insert themselves into a police chase. This isn't even a police officer who was at home at his kitchen table listening to the scanner and thought, oh my goodness, I'm close, I will get myself down there. This is a deputy who had just finished his assigned shift time, and contrary to what Mr. Carmen indicated, the testimony from the stand was that he was still within Knox County and on his way home when he heard that radio traffic. He's in uniform. He's in a marked police vehicle. He has on his police lights when he parks at the intersection of 150th and Route 150. And we know that because we can see them in the pictures and in the videos. They're still oscillating. Deputy Weist has been in contact with dispatch. He's asked for authorization from his supervisor. And once he's given that authorization, that's when he proceeds with deploying the stop strip. Official police duties. And then we have the defendant. Mr. Carmen has attempted to convince you that the defendant is not in control of the vehicle. And we know that isn't true. He had fantastic control of that vehicle because he drove it for 12 minutes from Galesburg at 100 miles an hour and managed to stay on the roadway that whole time until something got in his way. And then he had to make his decision, his fight or flight, and he chose flight. And how do we get around the stop stick? Just like Sergeant Kuhn explained to us, we can see the car, as the marks from the car as it travels off to the right shoulder. And as it travels back on to the roadway. And then there's the evidence that he talked about from Deputy Weist's vehicle, video from his vehicle. Or at that moment that it crosses over, you can see that the wheels on that Ford Taurus have turned to the right. Not continued to the left to try and get out of the way. No. We've turned to the right. That's one of those steering inputs that Sergeant Kuhn was talking to us about. And guess what else was to the right? Deputy Weist. Mr. Carmen would like for you to believe that the defendant didn't intend for this result to happen. We know that that isn't true as well. You're allowed to use your common sense here. You're allowed to make reasonable inferences. What could possibly be the intent of someone who is fleeing from the police at this high of a speed and firing shots? His intent was to not get caught, ever. And that's why we heard the evidence about the shots that were fired. And that's why we heard from CSI and we saw the diagrams about those. Because that was real. That's part of his intent. That shows you what the end game was here. One of the other comments Mr. Carmen made was about the speed of the vehicle and that it must have been traveling so fast that we can't possibly have believed that the defendant would have made an intentional decision during that short period of time from when the vehicle goes off the road to when it comes back on the road. And I'm going to remind you one more time that that's not the evidence that's in front of you. Because Sergeant Kuhn sat here and explained to us very clearly, even though it was math and I can't with the math, okay, that he didn't have enough information to determine the speed. We know how fast the Galesburg car was going. because we can see that in the bottom portion of that camera, okay? But that's the Galesburg car. And his testimony is he's doing his best to keep up with that Ford as it's fleeing from him. But the reality is, we don't know how fast that vehicle was going when it got up to those stop spikes. And that Sergeant Kuhn explained to us that you're gonna lose speed. No matter how fast you're going, you're gonna lose speed when you go off the roadway onto that sticky surface, which was a phrase I liked, hadn't heard it before, sticky surface. And then come back onto the road and we make those steering inputs. Those are all gonna decrease our speed. Less speed means more time to make decisions, but you know what? This defendant had 12 minutes to make his decisions. Mr. Richardson was determined to get away from the police at any cost. We know that from the speed, we know that from the time of the chase, we know that from his decisions along the way. He initially attempted to avoid that stop spike by turning the car towards the right ditch and driving it through the grass, and here's the worst part, ladies and gentlemen. He could have made it. How do we know that? Because we watched. We watched the Galesburg squad cars. At the end of Deputy Weist's video, we watched them drive on their right-hand shoulder and through the grass around the stop spike. He didn't have to turn back towards the left, towards the roadway. He chose that. This defendant certainly could have avoided the stop strip and continued his flight from the police, but he made that steering input to the Ford, causing it to come back to the roadway, turning it to collide with Deputy Weist. And it's all there in the crash reconstruction report. I ask that you find that Deputy Weist was a peace officer who was killed in the course of performing his official duties, and that this defendant murdered him. Thank you.
Thank you, Ms. Renfrew. Members of the jury, the evidence and the arguments in this case have been completed, and I now will instruct you as to the law. The law that applies to this case is stated in these instructions, and it is your duty to follow all of them. You must not single out certain instructions and disregard others. When I use the word he in these instructions, I mean a male or a female. It is your duty to determine the facts and to determine them only from the evidence in this case. You are to apply the law to the facts and in this way decide the case. You are not to concern yourself with possible punishment or sentence for the offense charged during your deliberation. It is the function of the trial judge to determine the sentence should there be a verdict of guilty. Neither sympathy nor prejudice should influence you. You should not be biased in favor or against any person because of that person's race, ethnicity, national ancestry, religion, gender, sexual orientation, age, disability, or socioeconomic status. From time to time, it has been the duty of the court to rule on the admissibility of evidence. You should not concern yourselves with the reasons for these rulings. You should disregard questions and exhibits which were withdrawn or to which objections were sustained. Any evidence that was received for a limited purpose should not be considered by you for any other purpose. You should disregard testimony and exhibits which the court has refused or stricken. The evidence which you should consider consists only of the testimony of the witnesses, the exhibits, stipulations, and judicially noticed facts which the court has received. You may, but are not required to, accept as conclusive any fact judicially noticed. You should consider all the evidence in the light of your own observations and experiences in life. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of, and others we might not be fully aware of, which is why they are called implicit biases or unconscious biases. Our biases often affect how we act, favorably or unfavorably, towards someone. Biases also can affect our thoughts, how we remember, what we see and hear, whom we believe or disbelieve, and how we make important decisions. As jurors, you are being asked to make important decisions in this case. You must resist jumping to conclusions based on personal likes or dislikes. You must not let bias, prejudice, or public opinion influence your decision. Neither by these instructions, nor by any ruling or remark which I have made, do I mean to indicate any opinion as to the facts or as to what your verdict should be. Faithful performance by you of your duties as jurors is vital to the administration of justice. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of, and other biases we might not be fully aware of, which is why they are called implicit biases or unconscious biases. Our biases often affect how we act favorably or unfavorably towards someone. Bias can affect our thoughts, how we remember, what we see and hear, whom we believe or disbelieve, and how we make important decisions. As jurors, you are being asked to make very important decisions in this case. You must resist jumping to conclusions based on personal likes or dislikes. You must not let bias, prejudice, or public opinion influence your decisions. You must not be biased in favor of or against any person because of his or her race, ethnicity, national ancestry, religion, gender, sexual orientation, age, disability, or socioeconomic status. Your verdict must be based solely on the evidence presented. Only you are the judges of the believability of the witnesses and of the weight to be given to the testimony of each of them. In considering the testimony of any witness, you may take into account his ability and opportunity to observe, his memory, his manner while testifying, any interest, bias, or prejudice he may have, and the reasonableness of his testimony considered in the light of all the evidence in the case. The fact that the defendant did not testify must not be considered by you in any way in arriving at your verdict. Opening statements are made by the attorneys to acquaint you with the facts they expect to prove. Closing arguments are made by the attorneys to discuss the facts and circumstances in the case and should be confined to the evidence and to reasonable inferences to be drawn from the evidence. Neither opening statements nor closing arguments are evidence, and any statement or argument made by the attorneys which is not based on the evidence should be disregarded. Those of you who took notes during trial may use your notes to refresh your memory during jury deliberations. Each juror should rely on his or her recollection of the evidence. Just because a juror has taken notes does not necessarily mean that his or her recollection of the evidence is any better or more accurate than the recollection of a juror who did not take notes. When you are discharged from further service in this case, your notes will be collected by the deputies and destroyed. Throughout that process, your notes will remain confidential and no one will be allowed to see them. The defendant is charged with the offense of murder. In parentheses, it says intent to kill or do great bodily harm. The defendant has pleaded not guilty. Under the law, a person charged with murder, in parentheses, intent to kill or do great bodily harm, may be found, 1, not guilty of murder, parentheses, intent to kill or do great bodily harm, and not guilty of aggravated reckless homicide, or 2, guilty of murder, in parentheses, intent to kill or do great bodily harm, or 3, guilty of aggravated reckless homicide. The defendant is charged with the offense of murder, in parentheses, strong probability of death or great bodily harm. The defendant is pleaded not guilty. Under the law, a person charged with murder, in parentheses, strong probability of death or great bodily harm, may be found, number 1, not guilty of murder, in parentheses, strong probability of death or great bodily harm, and not guilty of aggravated reckless homicide. Or number 2, guilty of murder, in parentheses, strong probability of death or great bodily harm. Or number 3, guilty of aggravated reckless homicide. The defendant has pleaded not guilty. The state has also alleged that when the defendant committed the offense of murder, in parentheses, intent to kill or do great bodily harm, and murder, in parentheses, strong probability of death or great bodily harm, the defendant murdered a peace officer when the peace officer was killed in the course of performing his official duties, and the defendant knew or should have known that the murdered individual was a peace officer. The defendant has denied these allegations. The charge against the defendant in this case is contained in a document called an information. This document is the formal method of charging the defendant and placing the defendant on trial. It is not any evidence against the defendant. The defendant is presumed to be innocent of the charges against him. This presumption remains with him throughout every stage of the trial and during your deliberations on the verdicts, and is not overcome unless from all the evidence in this case you are convinced beyond a reasonable doubt that he is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the case. The defendant is not required to prove his innocence. The state has alleged that the murdered individual was a peace officer killed in the course of performing his official duties. The defendant is presumed to be innocent of this allegation. This presumption remains with the defendant throughout every stage of the trial and during your deliberations on the verdict, and is not overcome unless from all the evidence in this case you are convinced beyond a reasonable doubt that the allegation is proven. The state has the burden of proving the allegation beyond a reasonable doubt, and this burden remains on the state throughout the case. The defendant is not required to disprove the allegation. Circumstantial evidence is the proof of facts or circumstances which give rise to a reasonable inference of other facts which tend to show the guilt or innocence of the defendant. Circumstantial evidence should be considered by you together with all the other evidence in the case in arriving at your verdict. The term peace officer means any person by virtue of his office or public employment is vested by law with a duty to maintain public order or to make arrests for offenses, whether that duty extends to all offenses or limited to specific offenses. A person acts recklessly when he consciously disregards a substantial and unjustifiable risk that circumstances exist or that a result will follow, and such disregard constitutes a gross deviation from the standard of care which a reasonable person would exercise in the situation. A person acts knowingly with regard to the nature or attendant circumstances of his conduct when he is consciously aware that his conduct is of that nature or that those circumstances exist. Knowledge of a material fact includes awareness of the substantial probability that the fact exists. A person acts knowingly with regard to the result of his conduct when he is consciously aware that the result is practically certain to be caused by his conduct. Conduct performed knowingly or with knowledge is performed willfully. A person commits the offense of murder, in parentheses, intent to kill or do great bodily harm, when he kills an individual if, in performing the acts which cause the death, he intends to kill or do great bodily harm to that individual. A person commits the offense of murder, in parentheses, strong probability of death or great bodily harm, when he kills an individual if, in performing the acts which cause the death, he knows that such acts create a strong probability of death or great bodily harm to that individual. To sustain the charge of murder, the state must prove the following propositions. First proposition, that the defendant performed the acts which caused the death of Nicholas Weist And second proposition, that when the defendant did so, number one, he intended to kill or do great bodily harm to Nicholas Weist, or number two, he knew that his acts created a strong probability of death or great bodily harm to Nicholas Weist. If you find from your consideration of all the evidence that each one of these propositions has been proven beyond a reasonable doubt, you should find the defendant guilty. If you find from your consideration of all the evidence that any one of these propositions has not been proved beyond a reasonable doubt, you should find the defendant not guilty. To sustain the allegation made in connection with the offense of murder, the state must prove the following propositions: that when the defendant committed the offense of murder, the defendant murdered a peace officer when the peace officer was killed in the course of performing his official duties, and the defendant knew or should have known that the murdered individual was a peace officer. A person commits the offense of aggravated reckless homicide when he unintentionally causes the death of a peace officer during the performance of his official duties as a peace officer by driving a motor vehicle recklessly and in a manner likely to cause death or great bodily harm. To sustain the charge of aggravated reckless homicide, the state must prove the following propositions. First proposition, that the defendant caused the death of a peace officer during the performance of his official duties as a peace officer by driving a motor vehicle. And second proposition, that the defendant drove a motor vehicle recklessly. And third proposition, that the defendant drove a motor vehicle in a manner likely to cause death or great bodily harm. If you find from your consideration of all the evidence that each one of these propositions has been proved beyond a reasonable doubt, you should find the defendant guilty. If you find from your consideration of all the evidence that any one of these propositions has not been proved beyond a reasonable doubt, you should find the defendant not guilty. When you retire to the jury room, you first will elect one of your members as your foreperson. He or she will preside during your deliberations on your verdicts. Your agreement on a verdict must be unanimous. Your verdicts must be in writing and signed by all of you, including your foreperson. The defendant is charged with the offense of murder, in parentheses, intent to kill or do great bodily harm. Under the law, a person charged with murder, in parentheses, intent to kill or do great bodily harm, may be found, 1, not guilty of murder, parentheses, intent to kill or do great bodily harm, and not guilty of aggravated reckless homicide. Or number 2, guilty of murder, parentheses, intent to kill or do great bodily harm. Or number 3, guilty of aggravated reckless homicide. Accordingly, you will be provided with 3 verdict forms pertaining to the charge of murder, in parentheses, intent to kill or do great bodily harm, a not guilty of murder, parentheses, intent to kill or do great bodily harm, and not guilty of aggravated reckless homicide, guilty of murder, parentheses, intent to kill or do great bodily harm, and guilty of aggravated reckless homicide. From these 3 verdict forms, you should select the one verdict form that reflects your verdict and sign it as I have stated. Do not write on the other 2 verdict forms for that charge. Under the law, the defendant cannot be guilty of murder, parentheses, intent to kill or do great bodily harm, and aggravated reckless homicide. Accordingly, if you find the defendant guilty of murder, parentheses, intent to kill or do great bodily harm, that would mean that the defendant is not guilty of aggravated reckless homicide. Likewise, if you find the defendant guilty of aggravated reckless homicide, that verdict would mean that the defendant is not guilty of murder, parentheses, intent to kill or do great bodily harm. The defendant is also charged with the offense of murder, parentheses, strong probability of death or great bodily harm. Under the law, a person charged with murder, parentheses, strong probability of death or great bodily harm, may be found, number 1, not guilty of murder, parentheses, strong probability of death or great bodily harm, and not guilty of aggravated reckless homicide, or 2, guilty of murder, parentheses, strong probability of death or great bodily harm, or 3, guilty of aggravated reckless homicide. Accordingly, you will be provided with 3 verdict forms pertaining to the charge of murder, parentheses, strong probability of death or great bodily harm, not guilty of murder, parentheses, strong probability of death or great bodily harm, and not guilty of aggravated reckless homicide, guilty of murder, parentheses, strong probability of death or great bodily harm, and guilty of aggravated reckless homicide. From these 3 verdict forms, you should select the one verdict form that reflects your verdict and sign it as I have stated. Do not write on the other 2 verdict forms for that charge. Under the law, the defendant cannot be guilty of murder, strong probability of death or great bodily harm in parentheses, and aggravated reckless homicide. Accordingly, if you find the defendant guilty of murder, parentheses, strong probability of death or great bodily harm, that would mean that the defendant is not guilty of aggravated reckless homicide. Likewise, if you find the defendant guilty of aggravated reckless homicide, that verdict would mean that the defendant is not guilty of murder, parentheses, strong probability of death or great bodily harm. The state has also alleged that the defendant murdered a peace officer when the peace officer was killed in the course of performing his official duties, and the defendant knew or reasonably should have known that the murdered individual was a peace officer. If you find the defendant is not guilty of the offense of murder, you should not consider the state's additional allegation regarding the offense of murder. If you find the defendant is guilty of murder, you should then go on with your deliberation to decide whether the state has proved beyond a reasonable doubt the allegations that the murdered individual was a peace officer killed in the course of performing his official duties, and whether the defendant knew or reasonably should have known that the murdered individual was a peace officer. Accordingly, you will be provided with 2 verdict forms. Quote, we the jury find that the allegations that the murdered individual was a peace officer killed in the course of performing his official duties, and that the defendant knew or reasonably should have known that the murdered individual was a peace officer was not proven, end quote, and quote, we the jury find that the allegations that the murdered individual was a peace officer killed in the course of performing his official duties, and the defendant knew or reasonably should have known that the murdered individual was a peace officer was proven, end quote. From these 2 verdict forms, you should select the one verdict form that reflects your verdict and sign it as I have stated. Do not write on the other verdict form. Sign only one of these verdict forms. Your agreement on your verdict as to the allegations must be unanimous. Your verdict must be in writing and signed by all of you, including your foreperson. And I have the first verdict form of we the jury find the defendant, Daylon K. Richardson, not guilty of the offense of murder, parentheses, intent to kill or do great bodily harm, and not guilty of the offense of aggravated reckless homicide. I have the next verdict form that states we the jury find the defendant, Daylon K. Richardson, guilty of the offense of murder, parentheses, intent to kill or do great bodily harm. The next verdict form I have, we the jury find the defendant, Daylon K. Richardson, guilty of the offense of aggravated reckless homicide. Then I have the next verdict form, states we the jury find the defendant, Daylon K. Richardson, not guilty of the offense of murder, parentheses, strong probability of death or great bodily harm, and not guilty of the offense of aggravated reckless homicide. Then I have the next verdict form, we the jury find the defendant, Daylon K. Richardson, guilty of the offense of murder, parentheses, strong probability of death or great bodily harm, and parentheses. Then the next verdict form, we the jury find the defendant, Daylon K. Richardson, guilty of the offense of aggravated reckless homicide. Then I have the verdict form that says we the jury find that the allegations that the murdered individual was a peace officer killed in the course of performing his official duties, and that the defendant knew or reasonably should have known that the murdered individual was a peace officer was not proven. And then the last verdict form of we, the jury, find that the allegations that the murdered individual was a peace officer killed in the course of performing his official duties, and that the defendant knew or reasonably should have known the murdered individual was a peace officer was proven. So if I could have my bailiff step up to be sworn in, please.
Jury in its retirement and keep them together, except by leave of court, that you will not speak to them yourselves, nor allow others to speak to them about this case. And when they have arrived at their verdict, you will bring them into court.
Okay. Where is Mr. Hoon? And where is Mr. Wyman? Mr. Wyman and Mr. Hoon, you are what we deem alternate jurors. So I know you sat with us all week, but you are not allowed to participate in the deliberations unless we need you. You are not discharged from jury service. I need you to give good contact information to Ms. Jeanette or Ms. Jane. Should a juror need to be replaced for any reason, then one of the two of you will be called back. So you cannot discuss this case with anyone. You can't go over any of the evidence, anything until either Ms. Jeanette or Ms. Jane call you to tell you that the deliberation or that there's been a verdict arrived. So thank you for being here all week. When you get back there, the two of you are allowed to leave, but you're not discharged until you get an official phone call from us. Do you understand, Mr. Hood? I do. Mr. White, thank you. So here are the jury instructions, if I may give those to you. And we are going to stand in recess. According to my computer, it is 11:41, and that is when the jury is getting the case for deliberation. And please be seated. Mr. Carmen and Ms. Runte, I'm going to assume that Ms. Terry Lynn has the ability to reach the two of you if and when we have a verdict today. Is that correct, Ms. Runte?
Yes, ma'am.
I'll be at the courthouse. I have a bond court thing at 2 o'clock, but I think that'll take 10 minutes. I'm hoping that we either don't or do have
Okay.
something done before then.
Okay. And then I'm going to leave contact people for your family, your responsibility to contact them when there's a verdict, Ms. Runte, and Mr. Carmen, I'm going to leave you responsible for contacting your family, family, and Mr. Richardson, obviously. So we'll get a hold of everybody. So I guess hang out.
Items of evidence, documents, back to the jurors, Your Honor.
They're allowed to have it. I can't, I mean, they were entered, other than that last exhibit, exhibit 28
Correct.
or what have you.
Are you going to go ahead and send those back to them now?
I usually wait until they ask for them, unless there's an objection. If you guys want me to go ahead and send it back to them,
I would prefer to wait.
I would prefer that they be sent so they have them to start with.
I'm going to send them back. I'm going to send it back because I mean, by the time they track me down and I track the two of you down and that stuff, so other than that last exhibit, because they were entered into evidence and they've been published, there's no sense in withholding it. Yes, take that one out, please. That's the only one. No, I have Hoon and Wyman as the alternatives. Did I not say Wyman?
No, you did.
Oh, Unless the attorneys are saying I'm wrong, but I wrote those two.
No, you got it right, Judge.
Okay, all right. All right, so we'll be in recess. Thank you.
Thank you.
I have to now as well, but I wanted to. Okay. I want you to